Good evening, ladies and gentlemen. Welcome. I suspect most of you know who I am, but my name's Maura McGowan. I'm the judicial member on the BAILII Board of Trustees. I'm delighted to welcome you to the 2025 Sir Henry Brooke Lecture. Henry Brooke was the founding chair of BAILII when the organisation was created 25 years ago. The lecture series has been named in his honour because he was passionately committed to access to justice and the idea that the law would be freely available to all, tenets that are still central to BAILII's ongoing work. We're very grateful to Herbert Smith Freehills, Herbies, as we didn't call them in my legal aid practice, for hosting this evening's lecture and making it possible for us all to join here at the office and for those of you who are online to join in. The firm has a long history of very generously providing support to pro bono work, to the charity sector, and we're very grateful to them for facilitating this opportunity to bring together all those who use BAILII, who support it, and those of us who are actually involved to a tiny extent, on my part, in the day-to-day running. I'm sure that everybody here knows what BAILII is and what it does. The charity, as I say, was founded in 2000 to promote access to justice by providing free, online, case law, legislation, and other legal materials. Currently, the BAILII website includes 139 databases of material from 14 jurisdictions, including England and Wales, Ireland, Scotland, Northern Ireland, some countries in Europe, and several others around the world. And the very small, and by that I mean very small team, uploads almost 500 judgments a week. Earlier this year, BAILII passed the milestone of having more than 500,000 searchable cases available. And its free resources include over 160,000 items of legislation. There are other freely available judgments, but BAILII continues to be essential in its provision of free-to-all access that covers multiple jurisdictions, includes hundreds of thousands of judgments, and has a deep collection of pre-2001 and historical judgments. It doesn't use cookies or trackers, and it is regularly consulted by millions of people. 2023, there were over 100 million page views, generated by almost 5 million users. But by 2024, the figures had increased significantly, 148 million page views and 14 million users. It proves how necessary we are. BAILII continues to offer free access to the law, but it's not free to run. We rely on the generation of our donors to maintain and add to our resources, and they're used throughout the legal profession, as well as the advice sector, in legal education, for litigants in person, and everyone who has limited or no resources to pay for legal information. We are always grateful to those of you who provide, from the firms, chambers, and other organisations, the contributions that keep BAILII going, but we continue to need that support. I hope you'll consider making a donation. Towards the end of the evening, Guy Beringer is going to do his Bob Geldof impersonation and really ask you for money, but please dig deep. This evening's event is going to run, I hope, fairly self-evidently. In a moment, I'm going to give way to the Lady Chief Justice, and after her talk, there'll be an opportunity for questions and answers. They can come from the room, obviously. Somebody's going to be keeping a record of questions coming up online, and we'll deal with those towards the end of the evening. As I say, Guy Beringer will threaten you towards the end, and after that, there'll be a reception. We hope you'll stay, mingle, speak to one another, and as I say, dig deep. Some of you will be too young to remember that phrase, but the others will help you. It's now my absolute delight to introduce to you the Lady Chief Justice, who, as you know, is going to speak about valuing judges. Before I do that, I'm afraid I'm going to take this opportunity to mention one point which is not quite so jolly. Some of you will know that I've been involved in working with women judges in Afghanistan, both before the government fell and since. There were about 250 women judges working there when they were allowed to. Some are still there. About 15 are here in this jurisdiction, but currently 3 are in Pakistan. They had been offered a means of leaving. That offer has been withdrawn, and they are likely within weeks, I say likely, the reality is it will happen, to be returned to Afghanistan, identified as women judges. What value on their lives when that happens? So whilst we sometimes feel we live in troubled times, sometimes worry about what's happening here, we should very much remember how very difficult it is for some. Can I, having said that, and this is going to be a horrible mispronunciation, I know, wish you all Navroz Mubarak, which I'm told is Happy New Year in Persian. The Lady Chief Justice came into a world where dinosaurs once roamed the earth, and sometimes they still do. But she is the first woman Chief Justice, and she has taken the place by storm. In case those of you who haven't followed what she has been saying regularly in the 18 months or so since she was appointed, haven't seen the stance that she has taken, there is no doubt to what extent she values the judges. She values us. Not because we're special, although obviously I am, but because, like public legal education, like access to justice, a valued and protected judiciary is an essential underpinning of a democratic society. And if you haven't already, look at what she said in the press conference earlier this year. Look at what she said in the House of Lords. She genuinely does value the judges, and she's my boss, so I'm going to be nice to her. The Lady Chief Justice.
Thank you. Thank you very much for the warm welcome. It is obviously a great pleasure to have been asked to give this year's Sir Henry Brooke Lecture. I was tempted to follow on from Baroness Kennedy's fantastic lecture last year on the state of the world. Very tempted. But in fact, this evening's theme for me is valuing lawyers. If anyone understood the value of lawyers, it was Sir Henry. He is still, of course, missed. As a barrister, chair of the Law Commission, vice president of the Court of Appeal Civil Division, president of the Society for Computer and Law, chairman of the Civil Mediation Council, to name but a few achievements, there was no area of law in which he was not involved. And of course, in playing a key role in the creation and the development of BAILII, he understood the fundamental importance of open justice. Different people inevitably have different views concerning the value of lawyers. Shakespeare famously gave expression to one type of view, the tyrant's view. In a fascinating study of how Shakespeare deals with tyranny across his plays, Stephen Greenblatt notes how in Henry VI, Part 2, Shakespeare explores what Greenblatt describes as fraudulent populism, and how Richard Plantagenet, Duke of York, stirs up a populist revolt, the aim of which is not to better the lives of the poor, but rather intended to place a golden circuit on his head. Part of that process is to stir up sentiment against lawyers, and that he does through manipulating John Cade, a headstrong Kentishman, to lead a revolt. And it is during one of Cade's speeches that a voice from the listening crowd utters the infamous line, "The first thing we do, let's kill all the lawyers." The tyrant's call throughout history. As Greenblatt puts it, Shakespeare knew that the line would get laughs, as it has done for the last 4 centuries. It releases the current of aggression that swirls around the whole enterprise of law, directed not merely at venal attorneys, but at all the agents of the vast social apparatus that compels the honouring of contracts, the payment of debts, the fulfilment of obligations. We blithely imagine that the crowd wants such responsible qualities in its leaders, but the crowd suggests otherwise. What it wants instead is permission to ignore commitments, to violate promises, and to break the rules. What it wants, as Shakespeare is suggesting, is that without lawyers, without the means to give effect to the law and hold all to it, the crown will rest all that much easier on the tyrant's head. What it wants is a world without the rule of law. Shakespeare has not been the only one to be critical of lawyers. Bentham in the 19th century was equally no fan. He dubbed the master of the rolls, not here this evening I see, a swindler. He referred to the relationship between judges and lawyers as a union of fraud and extortion. And at the same time as he was writing, Lord Eldon, at the time Lord Chancellor, was also weighing in. He had been appointed to chair a commission to investigate the problems then facing the Court of Chancery, of which he was in charge. They were problems with which we are also all too familiar today: complexity, cost, and delay in litigation. The commission reported in 1826. Was the cause of the problems the court itself, or its rules of practice? After weighty consideration, Eldon's commission concluded that no fault could be laid at his door. It was not the fault of either the court or its practices. No, the problem lay elsewhere. The fault lay with the carelessness of some parties, the obstinacy or knavery of others, or the inattention or ignorance of agents. Lurking underneath all this, of course, is criticism of the lawyer. Who else is responsible for the carelessness of the parties, for not advising them away from knavery or obstinacy? And who is the inattentive or ignorant agent, if not the party's lawyer? More recently, an echo of Eldon's complaint that the problems associated with the delivery of justice lie at the hands of lawyers can be seen in work carried out by 2 American scholars. They suggest that, in some simple cases, there is little evidence that lawyers make much of a difference. Worse than that, there is evidence from one study relating to unemployment benefit appeals that the only difference between cases where parties are represented and those where they are not was that the former took longer, in fact 40% longer, and increased time brings with it increased cost. Eldon would no doubt have nodded in agreement. But let me depart from these approaches, because in this evening's lecture, I want to explore how lawyers have value and why we should therefore value them and value them highly. Let me start by accentuating a positive, or rather a more accurate picture of the benefit that lawyers provide. The City UK's latest report on UK legal services makes the case for the economic value of lawyers in emphatic terms. In 2023, the legal sector contributed £37 billion to the economy, generating a trade surplus of £7.6 billion. It employed 368,000 people across the UK, 2/3 employed in London. And this income is generated not simply by UK law firms, but also the 200 global law firms with offices here. The total tax contribution flowing from professional services relating to the legal sector was approximately £30.9 billion. And then there is the burgeoning legal tech sector here, home to 350 companies, all contributing to our economic growth. And more than that, as City UK puts it, The UK's global reputation as a centre for justice and the rule of law is fundamental to the UK's status as one of the world's leading international financial centres. English common law is by far the most popular choice of governing law for cross-border contracts. The UK is also the world's leading centre for international dispute resolution in commercial disputes. And where dispute resolution is concerned, this is not only the work of the Commercial Court, the Chancery Division, the TCC and the Patents Court, but also the work carried out by our world-leading arbitration centres, arbitrators and mediators. Over 28,600 civil and commercial disputes were resolved via some form of alternative dispute resolution in the UK in 2023. It is sometimes easy, I think, to forget that the value derived from early, effective and cost-effective settlement via ADR is one that has really wide ramifications. As Lord Simon noted in D against NSPCC, society benefits if disputes can be settled out of court through negotiation between the parties, because companies and individuals who would otherwise expend their assets and their time on litigation can rather focus on developing their businesses, investing their time and their creativity in those businesses, but also in their private, in their social lives, and so on. And that leads me to a wider point. The value of lawyers does not just come from their role in litigation and the adjudication of disputes. It stems from what might be viewed as an invisible benefit, the very one that Shakespeare's would-be tyrants wanted to set aside in favour of rule by diktat, the rule of law. It is well known and generally accepted that societies committed to the rule of law are likely to be more economically successful than those that are not, or those that have weaker commitments to it than others. Can I be clear at this point? When I refer to the rule of law, I am very much not referring to rule by lawyers. A robust legal profession and an equally robust independent judiciary is a necessary component of the rule of law, and hence of intrinsic value to any successful society. But it is not a necessary and sufficient condition. It is one part of an overarching whole that goes to make up a healthy, open and publicly accountable democracy. Without, however, access to expert legal advice and, where necessary, representation, it simply is not possible to secure the rule of law effectively, again, as Shakespeare's would-be revolutionaries well knew. We have seen this point and its importance emphasised by the Supreme Court. I refer to the opinion of Lord Reed in the Unison case. There, the Supreme Court emphasised two aspects of the law that can go unnoticed and underappreciated. The first is the role that the law plays in shaping the framework within which businesses plan, innovate and invest, how they and individuals organise their affairs, enter into contracts, buy and sell property, how individuals develop their private lives, educate their children. The law, created by Parliament, and where appropriate the common law, is the framework within which we all lead our lives, and in this, as it has been called, law-thick world, it generally does so without the need for recourse to lawyers. It silently guides what we do each day. But, and it's a significant but, that framework is developed with the essential input of lawyers. If it were not for lawyers advising clients on the law when disputes arise, arguing cases before the courts, devising innovative arguments to test the intellectual mettle of our judiciary, appealing judgments where appropriate, as a society, we would not see that framework develop through court judgments. We would not see it clarified, and interpreted authoritatively. And where those interpretations and clarifications are viewed by Parliament to be in need of revision or correction, we would not see democratic course corrections. Lawyers and their contribution to the legal framework, its development and implementation in this regard ought therefore not to be underestimated. Without lawyers, we would have no effective legal framework. This leads to the second generally unnoticed value that stems from lawyers. Law does not always guide us silently, running in the background of our lives. As Lord Scott put it in the Three Rivers litigation, when explaining the importance of legal professional privilege, in the complex world in which we live, there are a multitude of reasons why individuals, whether humble or powerful, or corporations, whether large or small, may need to seek the advice or assistance of lawyers in connection with their affairs. They recognize that the seeking and giving of this advice, so that the clients may achieve an orderly arrangement of their affairs, is strongly in the public interest. Obtaining effective legal advice is the means through which individuals and businesses can order their affairs consistently with the law's demands, with the obligations and duties it imposes on them. And so again, it supports the rule of law. It not only helps promote social development and economic growth, it also minimizes the risk that disputes will arise, so it has a key preventive role to play. Effective legal advice is one of the means through which the costs and disruption of social conflict and legal disputes can be avoided. It's a means through which the adverse costs, both to individuals who would otherwise become involved in litigation and to society as a whole, which may have to pick up the costs flowing from the development of disputes and litigation, can be avoided. Prevention is better than a cure is a truism for a reason. Given the importance of giving effective advice to individuals and businesses, might we need to consider two things? First, to enhance the value that lawyers contribute in this respect, is there a need to review the scope of legal education and training? The point here is whether we need to introduce elements that help future lawyers to develop skills to identify where problems have arisen in the past, so as to help them advise their clients to take steps and on what steps to avoid problems arising in the future. Given the potential for AI to play a role here in the identification of factors that led to and lead to disputes arising in specific circumstances, does this call for the greater incorporation of AI education into law degrees and vocational training? A topic I will return to later. Secondly, is there a need to promote access to legal advice and assistance so the benefits of active prevention can be realised more broadly across society? When considering reductions in legal aid since the introduction of the 2012 Legal Aid Sentencing and Punishment of Offenders Act, the National Audit Office noted last year that the Ministry of Justice acknowledges the possibility that the removal of legal aid for early advice in some categories of law may have either increased its own costs by allowing issues to escalate and become more costly, or passed costs on to other government bodies. The nature of that possibility was fleshed out later last year in a report commissioned by the Law Society. Work carried out by Frontier Economics highlighted how unmet legal need, that is the absence of effective early legal advice, can result in significant adverse effects for individuals and, as a consequence, for society as a whole. An absence of preventive legal advice can, they noted, lead to increased homelessness, which can in turn lead to otherwise avoidable increased pressure, for example, on the NHS, and an increase in working days lost due to poor health. The similar absence of early advice can lead to otherwise avoidable short and longer-term adverse impacts on families, particularly where there is family breakdown. These reports focus on legal aid. The point is, however, a broader one. They highlight the importance to society of the law's preventive function, how it can prevent disputes developing and escalating. They highlight the benefits to individuals, businesses, the economy, society generally of early advice from lawyers. They pose an equally broad question, one that calls for society to consider, and I hope for lawyers to consider. How can we best secure access to such early preventive advice? How can we do it economically, efficiently, and so as best to be able to benefit society as a whole? City UK's latest report tells us that the UK is a global leader in legal sector technology and innovation. That tells its own story, doesn't it, about the strength of creativity within and related to the legal profession. Is there any reason why that creativity cannot be utilised to develop innovative and effective means to promote access to preventive legal advice, so that we are as strong in its delivery as we are in the delivery of dispute resolution in all its forms? I cannot believe that there is any reason why we cannot, and that the profession's significant value to society cannot then be enhanced further. I want to turn now, thirdly, to the value that the legal profession provides to the judiciary, to judicial futures. Sir Brian Levison once remarked that the criminal justice system was an ecosystem, and that, as an ecosystem, its vitality was a product of the effective interaction between its constituent parts and of their individual vitality. He went on to note how a structural weakness in their interaction, a fundamental weakness in any one or more parts, would undermine the system as a whole. The reality is that the whole of our justice system is an ecosystem. Civil, family and criminal justice, along with justice in the tribunals and the developing online justice system, all form part of a single wider whole. Both the judiciary and the legal profession form essential constituent parts of that whole. That connection can be seen through the fact that two of the regulatory objectives governing the operation of the legal profession are to support the constitutional principle of the rule of law, of which judicial independence is an inherent part, and that regulation should encourage an independent, strong, diverse, and effective legal profession. Just as the judiciary is and must be independent of government and of Parliament if it is to ensure that it can carry out its constitutional function, so the legal profession must also be robust in its independence of government, Parliament, and the judiciary if it is to carry out its, may I suggest, constitutional function. That it must be robust is important for several reasons, not least because it underpins how lawyers provide their clients with legal advice and assistance effectively, so that all in society are equal before the law. I want to highlight one specific reason, however, and that is the link that independence provides between the profession and the judiciary. It remains the case that the vast majority of the judiciary are drawn from the legal profession. There are, of course, notable examples where judges have been appointed from legal academia, Lady Hale and Lord Burrows being perhaps the two most obvious examples. The route from academia to the judiciary remains, however, underdeveloped. Given then that today's lawyers are tomorrow's judges, it is essential, I think, that they continue to develop their careers, committed to and exhibiting all the historical hallmarks of independence of thought, strength of character, and, where called for, moral courage to advise and act for individuals and businesses who may be unpopular, just as they would for any other client. And more than that they continue to exercise their independent judgment in advising and acting for their clients. If tomorrow's judges are to continue to demonstrate the robust independence of mind in the service of justice that has historically been the case and remains so today, it is essential that today's lawyers continue to develop that independence of mind. And it should be said that academic lawyers too demonstrate, through their research and the robust critiques of our judgments, the same essential characteristics. Maintaining the future vitality of the judiciary through maintaining the current vitality of the legal profession is not, I think, simply a question of ensuring that lawyers continue to learn and exercise robust independence. It is also a question of skills. Historically, when judges had less of a hands-on role in case management, were less involved in the management and administration of courts, and had less to do with technology, because there simply was less technology, expertise in the law, independence of mind, good character, and robust judgment were the essential requirements for judicial appointment. But a robust future judiciary calls for more than that. Today's judiciary needs to demonstrate effective management skills. It needs to be able to engage in and lead the effective administration of the courts. In some jurisdictions, such as the Netherlands, this calls for specific training in administration for those members of the judiciary with specific administrative roles. As our courts continue to digitize, and particularly given the increasing importance that artificial intelligence will have in the management and administration of justice, as well as its potential role in assisting us to carry out our role, it is essential that all judges are familiar with it, as they are with the administrative case management and adjudicative functions. Given this, it is all the more important that the legal profession continues to develop, as it always has done, its development of these skills as much as it has embraced technology. In that latter respect, I very much doubt that it is the case, as some suggest, that where technology is concerned, the legal profession has adopted a conservative approach. That it has not is evident from the lead that very many of our leading law firms have taken in the adoption of technology. My point, then, is that if we are to maintain the vitality of tomorrow's judiciary, we must maintain the vitality of the legal profession, so that tomorrow's judges are fully equipped to carry out the many aspects of their role upon appointment. If, as a society, we do not ensure that we have a robust legal profession that is able to do this, we thus harm another crucial aspect of the ecosystem of justice, the judiciary. This is particularly important where we consider the need to ensure that the judiciary is well equipped and experienced to deal with criminal and family cases as much as it is to deal with civil and commercial cases, as much as it is able to deal with public law cases as it is chancery matters, and that it is properly equipped now to consider and give effect to its new powers concerning the use of mediation, early neutral evaluation, and other forms of alternative dispute resolution. We must take care then to ensure that we are able to maintain the health of all areas of legal practice, for each has its intrinsic value as part of the whole. If we allow one area to atrophy, the whole will be diminished as a consequence. Where one or more areas of legal practice are under pressure, what steps can the profession as a whole take to support them and to support individual lawyers to develop valuable and rewarding careers within them? Careers that benefit society through enabling the public to access high-quality legal advice, and in the future benefited by ensuring that the judiciary remains strong, vibrant, and independently minded. More than that, and reverting to the topic of education, do we also need to consider how we ensure that our lawyers have the necessary training and skills? This may mean revisiting the nature of legal education. Given that 21st century legal practice is and will continue to become a practice that requires an understanding of technology, and AI particularly, do we need to ensure that all law students are required to undertake appropriate courses as part of their law degrees, their vocational training, and their continuing professional development? Where insights can be gained from other subject areas, might we want to consider how they can be incorporated into legal education? It is, for example, standard practice now for universities to provide 4-year law degrees, with one of these years spent studying law in a university in another country. The benefits are obvious. Might we want to adapt that model so that one of the 4 years is dedicated to studying computer science, AI, psychology, finance, and so on? Some universities are already doing so. Might it be an approach that should be generalized across legal education, so that all new entrants to the profession are fully equipped in these areas for developing their practices in the 21st century, and from there, for those who want to do so, to enter the judiciary in the course of their careers? And all this leads me to my final point: ethics, standards, and effective regulation. Lord Bingham, when Master of the Rolls, famously held in Bolton and the Law Society that solicitors had to be capable of being trusted to the ends of the earth, a statement made in the context of solicitors' regulation. There is a need to maintain the reputation, he said, and to sustain public confidence in the integrity of the profession. And why? If a member of the public sells his house, very often his largest asset, and entrusts the proceeds to his solicitor, pending reinvestment in another house, he is ordinarily entitled to expect that the solicitor will be a person whose trustworthiness is not and never has been seriously in question. Otherwise, the whole profession and the public as a whole is injured. A profession's most valuable asset is its collective reputation and the confidence which that inspires. The same applies, and sometimes more so, when an individual places responsibility for their liberty, their immigration status, their business dealings, their claim for damages for personal injury, their family circumstances, in the hands of their lawyer. It is fair to say that Lord Bingham's words have resonated loudly in recent years. Professor Moorhead, in his recent Hamlin lectures, has pointed to concerns about the legal profession's involvement in the post office scandal, and we can all think of high-profile collapses and subsequent regulatory investigations into law firms. More broadly, as the Legal Services Board has recently summarised it, evidence shows that lawyers are sometimes failing to act in an appropriately ethical way in other circumstances which range from unintentional behaviour through to more severe, intentional and even criminal conduct. which includes misleading courts and compromised independence, the misuse of non-disclosure agreements, and the use of strategic lawsuits against public participation. For a critic such as Bentham, the various examples would support his view that the legal profession's worth to society was somewhat less than it might consider it to be. For Lord Bingham, they would have underscored the importance of that most valuable asset, the profession's reputation and client and public confidence in it. For others, like Professors Moorhead and Higgins, it suggests that reforms may need to be made to legal professional privilege so that it cannot, as they suggest, be misused, particularly by in-house legal teams. For the Legal Services Board, the various concerns they highlight suggest a need for regulatory reform focused on ensuring that the primary legal services regulators provide the right framework to give effect to professional ethics across the profession, as well as the right level and type of support to ensure that the framework is effective. Undoubtedly, there will be detailed discussion of the reforms that are needed to minimise the risk of future unethical conduct, so that the profession's reputation is not called into question, as it has been in recent years. And just as importantly, that the profession is able properly to deliver the value to its clients and society in the form of proper and effective legal advice and assistance, even where that advice, that assistance, involves telling the client hard truths. One question that may need to be considered, though, is whether and to what extent the various recent and troubling examples have been as much a consequence of the approach we take to regulation. That was certainly the view taken by Professor Stephen Mason in his independent review of legal services regulation. As he concluded, the current regulatory structure provides an incomplete and limited framework for legal services regulation that is not able in the near term and beyond to meet the demands and expectations placed on it. And in March of last year, Sir Bob Neill, then chair of the Justice Select Committee, while noting in a letter to the then Lord Chancellor that the legal profession was a vital and internationally significant industry which makes a major contribution to the economy, was clear that whilst there was no real appetite to review the current regulatory regime, it was, as he put it, undeniable that the case for re-examination of the legislative framework underpinning regulation is growing stronger and stronger. These are, of course, matters for the Executive and Parliament to consider. In thinking about whether to review, and if so, what might be the scope of such a review, several points might beneficially be explored. First, what does the long view tell us? Is there evidence that professional and ethical standards have declined overall in the last 20 years, or at least since the introduction of the post-2007 Legal Services Act regulatory structure? Secondly, if there is such evidence, is the regulatory structure the or a significant cause of that decline? It is argued that outside the legal environment, that poor behaviour is a symptom of poor environments. Is that the case here? Thirdly, if the regulatory structure is not the or a significant cause, what then are the causes? And how can the challenge that they create be met effectively? That too may lead to a conclusion that regulatory reform is needed. It may also lead to the conclusion that changes need to be made to legal education, so that professional ethics is not simply a part of the vocational courses, but becomes an integral part of law degrees. It is not for me to suggest, and I do not suggest, any answers to these questions, but they are perhaps questions that could usefully be grasped. The profession cannot allow itself to be misunderstood, as might well be the case, become the case, if recent examples of poor professional and ethical standards continue to increase. To take the view of ethics best left to Alfred Doolittle. Those of you familiar with Pygmalion, My Fair Lady, will remember the father of Eliza Doolittle, when asked if he had no morals, retorted, "Can't afford them, governor." To ensure that the profession continues to be highly valued, to minimise the risk of unethical conduct that calls into question its value then, it is of fundamental importance that the right regulatory structures are in place and that the right approach to the teaching and maintenance of professional ethics is in place. That is the challenge. I have no doubt that it can be met. So, in conclusion, the rule of law and economic growth, effective legal advice, the prevention and resolution of disputes, the provision of the judiciary of the future, one that reflects the breadth of society, underpinned by sound legal education, professional ethics, and effective regulation. Taken together, they articulate the significant value that lawyers provide to society. As a charge sheet goes, that seems to me to be a rather impressive one that more than answers the cynics and the critics. Can I leave the last word to Sir Henry? 20 years ago, giving a lecture on access to justice and judicial review, he commented on the need for serious consideration to be given to the cost of justice and who is to pay for it. If I can adapt his words, all of us who care for justice and for the rule of law must, I think, start talking seriously about the value of lawyers to the delivery of justice and a just society. There is a powerful story to tell. It is one that lies at the heart of any vibrant, open society. Thank you very much.
Right. We've now, as we said, got some time for questions and answers in the room, and then I'm relying on Yvette, I think, to tell me if we've got questions online. But we'll start in the room. Yes, if you could wait for them, it's coming up behind you, as they say, pantomimes. Right.
Thank you very much indeed, Mom. There is an unusual practice in English law which has been here for over 20 years. And that is that in all pleadings and the key documents, there's a requirement for a statement of truth, whereby counsel and solicitors are meant to properly indicate what their defense is, or whether they truly believe on the evidence that is before them that is the case. It has come to my knowledge very recently that certain of the very large firms are tending to avoid use of this particular provision in their protocol letter arrangements. I have had correspondence with one of the major firms where they've said, when I've asked them that all statements coming to me and the protocol letter stage needs to be under a statement of truth, they've come back and said they don't understand what I mean by a statement of truth. This is complicated by the matter that large firms these days tend to have just a name of the firm rather than the partner or article clerk or whoever is actually dealing with the question itself. Would you like to comment upon this growing practice and difficulty?
Not really.
Yeah, I'll tell you what we'll do, and because I think it's always valuable in these things to take two questions at a time, and then let the Lady Chief answer in turn. Probably it would be greatly appreciated if the questions related to the content of the lecture as well. But here we go.
going slightly off the content of the letter, but not perhaps quite as much as that. Your co-equal, the Chief Justice Roberts of the United States, has found it necessary to reprimand the president, President Trump. Why do you think that can happen in the United States, and do you think there's any risk of that kind of thing happening here?
So, two tricky questions.
Would you like me to get a third, and then we'll see if we can?
I think that the events that we are witnessing in America, I think I can neutrally say, are troubling for all of us. We, of course, have the Constitutional Reform Act. We have a Lord Chancellor who has specific statutory obligations to defend the rule of law and the independence of the judiciary. But I think we are all watching very carefully what is going on across the Atlantic, Michael. I'm not aware of your particular issue, sir, but I certainly do remember, it's been a long time since I've advised a client on the dangers or importance of the statement of truth. But I do think protocol correspondence is extremely important, and whether or not there is a statement of truth on it or not, it will come back to bite you if it is inaccurate, because it is there on the record forever and a day. So I don't know what people are advising their clients, but I would certainly exercise caution and treat a pre-action protocol letter with enormous gravity, given cost consequences, but also the consequences for the merits of your claim. Adam, will that do as an answer? That'll do. Yes. Closer, sure.
Do you want, at this moment, stick with the room? If you got anything online, do you want to read those out, Yvette?
So a question from the online viewers. Lawyers value lawyers, but why don't the general public, regularly ranking them second in the league table of most despised professions between politicians and estate agents? Why doesn't the powerful story resonate with them?
Well, doesn't that go back to where I started in my lecture, the Shakespeare stuff? I think that we are easy targets. If we limit your question, Ian, to judges, judges don't speak out as a rule, except through official channels. They speak through their judgments. So we rely on others to defend us. You still can't hear the answer. You can now. Good, Peter. Hello, Peter Roth. I think it's a combination of factors, but I think my short answer, Ian Christie, would be that we are easy targets and perhaps misunderstood. I, as you know, often think that the solution to many problems is good communication. I think the more we can do to be transparent, people to see that we do the work that we do as lawyers, through BAILII, through access to justice initiatives, and as judges, the better. But I also believe that sometimes people don't want to understand what we do, and however transparent and good we are at communicating, that message will not be broadcast.
Yes, there's two there, one there and one up the front. So if we do those in turn, if we hear them both, and then do we start at the back?
Hi. As law is such a critical and fundamental pillar of society, do you think that understanding law should go back to secondary school and be taught in secondary school rather than just in university?
Yes, absolutely. I mean, all the outreach work that I'm sure everybody in this room does, that I do, we do, the judges do. You've got to make the rule of law real, and there's a whole other lecture there. What does it mean? Different things to different people. It's not a useful phrase for children. I go out and I say, well, the rule of law is why you can cross the road safely, because you can look left and you look right and you look left, and cars drive on the right-hand side. It's why you can buy a sweet in a shop, because the rules are you go into the shop, you choose your sweet, you go to the till and you pay for it. I think that will be a fantastic idea. So the more and the earlier understanding, the better, is my personal view.
Thank you.
Right, I sit at Croydon Magistrates Court.
Yeah.
You can tell how much a society values different professions by how much they're paid. So why aren't lawyers, particularly magistrates court, paid more?
Well, most magistrates aren't paid anything.
But sorry,
The
lawyers in
unpaid
magistrates court.
professionals, the lawyers, the legal advisors.
Yeah,
you
the
mean?
legal advisors, yes.
Couldn't. She stutters. I think that recruitment and retention of legal advisors, who are absolutely essential to the administration of over 90% of criminal justice in England and Wales, is absolutely key. And we know that it is one of the least well paid areas of activity within within this area. So it is enormously important that we are able to recruit and retain legal advisors. And as you rightly point out, I think what you're saying is that we lose legal advisors who are really great to other departments, such as the Criminal Prosecution Service elsewhere, where they will be better paid. Most of them would like to stay if they could.
Yeah, that's exactly right.
But the financial problems are so great. But I mean, the magistrates, just to give them a shout out, I mean, they are extraordinary. The great unpaid professionals who serve our country every day, and as I say, deliver more than 90% of criminal justice of all cases are done in the magistrates' court. And self-evidently, because they are not lawyers, they cannot function without a legal advisor in the courtroom. So without legal advisors, we have magistrates' courts standing empty and not functioning.
Yeah, thank you for that response.
One here, and then one over. Yvette, there's one over here as well.
Thank you for your lecture and defending our profession so eloquently. You referred to the ecosystemic threat that the weakening of any constituent element therein might pose. And I wanted to know if you considered there was a risk in terms of the quality of judgment or legal understanding, or the signal that certain areas of work might be deprioritized by a paucity of family practitioners or criminal practitioners or general legal aid work at the higher levels of the appellate judiciary?
Yes, I think that we are suffering here and now with lack of criminal barristers, lack of criminal defense lawyers, not just barristers, solicitors, criminal defense solicitors, and that feeds all the way up to the top. So it is, as you say, all part of the ecosystem and a very important part of it. So I do firmly believe what I said. Well, there's an oddity, that I do think that we are all interlinked constituent parts, and I don't think you can separate anyone out from the other.
Thank you, Baroness Carr. I'm a Polish-American citizen. I came here 6 years ago and qualified as a solicitor, and I currently practice primarily in criminal defense and asylum legal aid practice. I'm sad to see that there's not more of us entering the profession, but perhaps that will change. There's 2 points that I was confused about when I arrived in the UK. The first, when I first encountered the BAILII database, I was profoundly confused as to why there was not more calls for the government to fund a database or to keep legislation.gov.uk up to date. I did not understand, and I still don't understand, how it can be that Lexis and Westlaw can have pieces of legislation updated quicker than legislation.gov.uk. I wonder if you have any observations on that.
No, I mean, I actually haven't made that connection, so it's a very good point. Thank you. I've made a note of it. Obviously, I don't hold the levers here, but it is an interesting observation. It's also very interesting in an area such as the ones that you practice in, where there is so much legislation and it is so fast moving, isn't it?
Indeed. I mean, I suppose where the confusion stems from in part is that I presume for the two companies that run those databases, it's in their interest to maintain a duopoly on the market. But I wonder whether there's ever been any efforts by the trustees of BAILII in order to convince Parliament or the areas of government in order to simply take away that duopoly. And I was
quite rightly whispering the National Archives, but
well, there's a whole different. I see my predecessor's chair, Sir Ross Cranston, Mining Riley. There's a series of issues there. The government did, in fact, take judgments in case law distinct from legislation, obviously, to the National Archive. We politely pointed out to them that covered part of the United Kingdom, but that Scotland and Northern Ireland were actually of some importance in the justice ecosystem. I put it no higher than that, coming from Belfast. Yeah, there's a complex series of arguments. Actually, the point there is more what resource does the state put into this rather than how sophisticated. I mean, private entities should be encouraged to be as sophisticated, swift, and capable as they can be. Removing, I mean, say they've got a duopoly, you know, you'd have to then get into what are the barriers to entry for that market, which they may not be as high as people think, particularly in the modern world of AI, which will have occurred to them. So there's a complex series of issues there. I think the point you're really making is that it is faintly surprising that government does not invest more in this area across a range of ways, which, and if I could draw that, if I could abuse privilege and have the final question, because I think some of you look thirsty, to the Lady Chief. I was taken by your comments about the financial cost of actions taken not only by the Ministry of Justice, but others as well in the justice system, and indeed that, to some of us, slightly amusing acknowledgement that their actions did have a knock-on series of ongoing costs for other departments, which had been apparent to everybody else for some 50 years or so. My question actually was this: do you think, and it came to me most significantly actually when I was reading the discussion about cap on sitting days, at the same time as I was reading the impact assessment the government had done on the Employment Rights Bill. I don't attempt to draw you into either of those things, but one, which was by chance the measure that the government wanted, had an economic assessment of some billions related to what it said were the additional well-being years and the economic value of those well-being years, which would come from what the government said were reforms to employment rights. There was no economic assessment of capping sitting days in terms of the loss of well-being years to others across the economy, despite the fact that that's a well-known measure that Treasury has. So my question, which I'll finally come to, is do you think we would benefit from having some entity which was formally charged with placing an economic value on government actions, which obviously you mentioned early legal advice, but there's all sorts of areas. Sitting days would be another, which would have to be used to say this is what it costs us.
I think, you know, I think for too long justice has been viewed as being in a silo, and it's just not. And what I've been trying to do for the last 18 months is to get everybody to lift their eyes up and realise that we are connected to everything. We are connected to economic growth. We are connected to families, to mental health, to physical health, to productivity. There is no part of society that we don't touch, and we have the exercises to make that understood and valued. Now, some of it you can't put a value on. It's about societal moral values, being happy, being respected. You know, having a healthy society with good attitudes, a diverse society. But there are things you can value, and there have been attempts to value, for example, the mental health costs associated with litigation. So the stress of litigation, even as a lawyer, advising the client is bad enough, but we all know about the stress of clients and the impact. See, there have been attempts, but I think it would be a wonderful thing, self-evidently, you know, if we could have an organisation expert at doing this. I mean, it is difficult to do sometimes, but it surely can be done, at least, you know, in a general way, to give us a steer. Yes, so yes, thank you, Guy.
Good. Well, we'll have to think how we do that. I should draw us to a close now, firstly by, again, thanking the Lady Chief Justice for her excellent lecture. As many of you will know, the Lady Chief Justice gets a significant number of requests to speak at all sorts of different things, and she is notably tirelessly enthusiastic in her response to those requests. So I wanted not only to mark our gratitude BAILII that she had in fact chosen us amongst, I think, a plethora of other requests, but also perhaps to say that there is a broader gratitude. We've talked quite a lot about the wider justice ecosystem, not just the criminal justice ecosystem, the whole, across the whole waterfront. She does an enormous amount to support that ecosystem. It goes considerably beyond the statutory duties placed upon her for supporting that system. And I just did want to say that we do notice that, and we are going to need it rather more, I suspect, in the period ahead of us. But that is noted and enormously appreciated by all of us and others as well, I think. I should also thank all of you here and online for attending, particularly those of you who support BAILII financially, so you'll be let out in a second. We, as Maura said, we are a charity. We rely totally on donations from chambers, law firms, Inns of Court, legal associations, librarian associations, and individuals. We get no government assistance at all. So those of you who are not donors actually do have an opportunity to rectify that. We have a growing number of individuals, not a great number, a growing number, small but growing, of individuals who support BAILII financially by regular giving. And I should say I'm amongst them. I give a modest monthly sum to BAILII. It's probably, I was thinking about it, it's probably about the equivalent of 3 bottles of wine a month. Now, that gives rise to 2 questions I can see in your eyes. One, you're thinking, what the hell does he drink? But frankly, this is a sort of self-guiding principle. It can be driven by whatever you drink. 3 of them a month. But if you go online, and those of you who I know are watching online, as soon as I started speaking, have probably been scrolling down your phone, social media anyway. Pay attention now. Actually, on your phone, if you open up the BAILII website, there is a button which says donate in the middle of it, and you can't really miss it. Please do try that, because that, if a significant number of you do that, it makes an enormous difference to us, because we start every year having to get past 200,000 in donations. Now, we have a number of regular donations, but we do need that. If you represent an organization that does not yet support us, and you can tell whether they do by looking on the website, please just come and see either me or Maura or Yvette or Anne, and we will show you how you go about rectifying that. We've got ready-made materials to give to any organization to show if they're motivated by doing good and supporting social welfare law. Our user base is predominantly social welfare lawyers and students. If, however, they're just interested in their own affairs, actually nearly every firm has a huge user base amongst its staff. Everybody uses BAILII. Very few pay for it. And we do need to rectify that. So whether it's an organization, come and tell us. We'll give you the wherewithal to go to the budget holders in your organization. Individuals, those of you online should probably have just about completed it by now, I think. But I do hope, yes, on your 3rd bottle at least. Now, our bottles are waiting, so I think I should just close by thanking again Herbert Smith for allowing us here to use their space, but also in a moment they're going to provide refreshment. Thank also Andrew Wells for making the introduction and working hard to get us in here. Andrew's a partner in Herbert Smith, but actually I have to say he's also my nephew, so he didn't really have any choice. Now I've embarrassed him. So that's probably enough from me. But back to the point about financial support is a serious one, because if you don't support BAILII, it will cease to exist. And life's pretty simple sometimes. It's as simple as that. So please do that. And I think Yvette, sorry, I thought Yvette was signaling to me from the back. She's just putting the microphone apart that I've done something wrong. I probably have. But I'll close now. Please join us. Andrew will show us where the drink is in a second. But if we just close again by showing our appreciation to the Lady Chief Justice.